All advice given is for general information purposes. All legal cases are different, and you should seek the advice of your own attorney before acting or making decisions. No attorney-client privilege applies to communications on this show, and no attorney-client relationship is created by calling or writing in. Attorney Rominger practices only in Pennsylvania and maintains his primary office in Carlisle, Pennsylvania.
Welcome back. 540-0580. I'm going to answer your legal questions here today. I'm done talking about quantum easing. Don't worry. I'm done, okay? I know it's boring the hell out of you guys, but I had to do it. I had to fix you. I had to get your mindset right so you know what's going on. Now you know. Chuck, you're on the air.
Yeah, I got a question about how you handle ethics.
Okay.
Because you always have conflicting ethical quandaries.
Oh, we always do, yes.
As a lawyer. And, obviously you defend people who are, you may know are guilty, but you have to try to defend them or get them lesser crimes. And This brings into the case I'm referring to is one in Philadelphia, not one that you did.
Okay.
In Philadelphia, they had a gentleman who was in prison for having an illegal gun, and that's what it was reduced to. So he served 4 years for having an illegal gun, got out of jail, and 10 days later killed a policeman in Philadelphia, of course with another illegal gun. And obviously the defense attorney that had represented him had actually gotten whatever case was against him reduced to much less charges, and gotten things done. How do you, when something like that happens, do you go, well, I'm going to do pro bono for 6 weeks, or...
No, well, I guess you could do penance, right?
Right.
But the answer is you have to define what your calling is. And if your job is to defend the Constitution and assist the client that you're representing at any given moment, then your duties are to those two things. And you have certain duties to the court, under the tribunal, etc. So you have to sort of lay all those out. But when you get back to the point where, I free somebody who then goes on to do something terrible, is that my fault that they went on to do something terrible? Well, the answer is no, because you could say, but for the fact that I freed them, they did something terrible, right? But you could also say, but for the fact that their parents procreated, they did something terrible. But for the fact that their grandparents procreated, they did something terrible. And you can just draw back through their lives a line of all the but-fors that every person, but for the fact that their 8th grade school teacher was lazy and didn't realize that they were, going off the wrong path and take time to call the parents up, but for the fact that the parents didn't care, but for the fact that the school underfunded the guidance office, but for the fact that, so you can keep going through that in your mind, or you can say, I don't have control over what every person does. All I can do is do my job to the best of my ability. That's one easy way, right? But then you could still get this nagging feeling about what's going on. Why did I really assist this person? And I think the important line to draw that I think most lawyers draw, and I do, is the difference between helping somebody clean up what they've done versus assisting somebody in the actual perpetration of a crime. So I think we can draw a pretty clean line. Now, the flip side is, for lawyers, let me turn it around on you for just 1 second. Think about this ethical dilemma. I have a client that I know is innocent, or as certainly as I can know they're innocent, I believe them to be innocent. And they believe themselves to be innocent. In fact, let's say they maybe even are, but we're pretty sure, so we'll just say it's approaching 100%. But they're facing a very lengthy prison sentence, and the district attorney comes in and says, well, if he takes a felony, I'll give him probation. Ethically, I've got to advise the client on all the risks and the rewards. But think about the position I'm in now. Now I've got to tell an innocent guy that it's in his or her best interest to plead guilty to a felony they didn't commit, because otherwise they're going to go to jail longer. And so I find myself talking them into a plea deal that really is in their best interest, arguably, but perverts justice because an innocent person is getting tagged with a crime they didn't commit. but it's in their best interest. But it's still a perversion of justice.
Right.
I mean, they hit us on all sides.
I mean, I'll give you the weirdest one or something like that. Suppose you have two clients.
Right.
And one is charged with a crime that another one of your clients told you he did. How do you resolve something like that?
Well, that's extra problematic. Now, interestingly, you can go to the other client and say, you read in the newspaper that Bobby Sue's charged with your crime. Are you willing to own up to it so that an innocent guy doesn't go to jail? Now, what do you think the odds? The odds are they're going to say sure. Almost approaching zero on that one, right?
Right.
So in that, and actually, there is an issue with that because there was a lawyer who wanted to come forward because there's somebody who's on death row somewhere, but he had a client that confessed to him to doing it and basically gave him some other information which apparently could free this guy, allegedly.
Right.
And the lawyer went to the court and asked for permission to divulge what this person told him, basically hinting that it would be very helpful for resolving this other person's claims of innocence, and hinted around as best they could as to what they would provide. And the court said no, because that privilege survives, and he can't just release that information without that person's consent. But they're dead, so he can't get their consent. So there's a lawyer walking around who could exonerate somebody, but the court system says no, people need to know that the privilege is so strong that they know that even after they die, the privilege will still continue to protect them. So we balance out this guy laying in jail, potentially could be freed. Now, of course, the evidence could turn out to be completely worthless, too.
Right.
But I suspect this lawyer has some dynamite, So should he write it on a cocktail napkin and slip it into the other lawyer's mailbox some night? Is that ethical? I mean, is he because he's gonna wrong or right or wrong by breaking some rules? That's probably not good, because that's the slippery slope. Because all wrongs can be righted by breaking some rules if you tell yourself that often enough.
So I'm just.
No, I'm just thinking out loud.
It gets very complicated when somebody asks you, in this whole ethics game of what you feel. At least you have some defense of saying you're doing the best job for your client, and that's what you're ethically challenged to do.
Yeah, and that's the thing. Now, let me put it this way. When you're providing professional service, like a doctor even. Does the doctor have to be concerned about how doing a procedure a certain way is going to affect the insurance payments and his business and what Medicare is going to do? And does the doctor have to worry about giving you antibiotics versus giving antibiotics to every person who comes in because the CDC doesn't want him to give away antibiotics like candy anymore, right? But he thinks maybe in your case the protocol probably he doesn't want to violate the protocol, but he thinks maybe in your case he should. He has to weigh out competing interests, which is the interest of the many versus you, et cetera, et cetera. I think it becomes acute when you have like the triage nurse, right? Trying to decide which person that gets treated first. But my point is there's always all these dilemmas, because anytime you're trying to help somebody or have agreed to help somebody or try to protect somebody, you're going to run into that wall. I got to go to break.
I'm just wondering, from your standpoint.
Yeah, go ahead.
Is there you go through the fifth, literally, afterwards, something like that happens?
You know what? No, I usually only go through the fifth when I have the and we don't mean the Fifth Amendment here. We mean the fifth of the bottle.
Right.
That happens usually when I'm sure somebody's innocent and has gotten tagged with something they didn't do.
Or you helped somebody that does something horrendous later on.
Yeah, and I don't think I've really experienced that per se, but you never know. I mean, you never know. And of course, the flip side is, again, although I did tell a prosecutor that one time, and he said, you should have done this, and you let this guy out on the street. And I'm like, well, hey, dummy, if you'd have done your job better, he wouldn't be on the street. So I'm putting the blame on you.
Right.
But that was just two angry attorneys in the hallway. All right, I got to go to break. Take care, Chuck.
All right.
540-0580. Welcome back. Carl Rominger here, 540-0580, answering your legal questions, of course, throughout the week. If you need to get a hold of me, go to romingerlaw.com, and you can find our contact information. We're always happy to assist you throughout the week at the law firm, 241-6070, 241-6070. I got to give that phone number because a few of you, 3 of you to be exact, still don't have Internet access. Lancer, you have a question on divorce and custody?
Yep, I'm in so here's my situation. I'm in the process of getting a divorce, and I have 2 young children, so custody is involved. In the beginning, my soon-to-be ex was sharing the children 1 week on, 1 week off. Then she decided that she was not going to share the children. My attorney filed some type of emergency order. Then she shared the children for a week, and when she got them back, she's back to doing what she was doing before, not sharing the children.
Right. Maybe time to file a contempt.
Yep. So my court date is in November. So my question is, do most people fight this? And my concern is, if I don't fight this, the judge may think I'm not interested in the custody of my children. So what do most people do in these situations?
Yeah. Well, children are like trademarks. If you don't defend your position, you may lose it. And what do I mean by that is, you're right, a judge can perceive, and I've seen this happen, you're complaining that you didn't see your kid or this happened or that happened, but it all boils back to that this has been going on this way for 2 years, and now that's become the status quo. And you've allowed this situation to escalate to the point where, not seeing your kid for 2 years, you're not going to just suddenly jump right back into your kid's life and get the custody. So we're not going to find this lady in contempt when it seems like you, by acquiescence, agreed to at least a unofficial modification of the order. That's why I would counsel you to go forward. The other reason is, you have to slap a hand only so many times, a lot of times, before somebody realizes that each time they do something stupid or in violation of the order, they're going to get yelled at by the judge and pay your attorney's fees.
Okay.
So you're hoping that coerces. The other thing is, findings of contempt can become useful later should you decide that you want to go for more custody. Because the inability of a parent to facilitate the relationship with the other parent is a basis to switch custody into the other non-custodial parent if the custodial parent is not promoting the relationship.
Okay. And my last question, if you have time, at a high level, what does the court look at whenever how they decide who's going to get custody of children?
Okay. The statute now has 16 factors in it. Number 16, by the way, or letter 16 or whatever that is, in the legislature's wisdom is any other relevant factor, okay? But basically it's things like which parent has the best environment, which parent can nurture the child the best. In fact, if you listen to the show here, what I'll do during the break coming up here,
okay,
I'll pull up the 16 and we'll go through it at the bottom of the hour here.
Okay, so you're going to do that on the radio?
Yeah, I'll do it right here on the radio. We'll go through them and I'll just kind of editorialize a little bit. That'll be something fun to do.
Okay.
All right. So hang tight for some custody stuff.
Okay, and these 16 points, are they by any chance on your website or?
I will post a list to my Facebook page as well.
Okay.
And it's Carl with a K, Rominger, Rominger. Just friend me, but I'll make it public.
Okay.
All right, brother.
Super.
All right. 540-0580. Dan, you've been holding patiently.
Yes, I have a question about class action lawsuits. I have. It's funny you just mentioned for those 3 people of you that don't have internet. I may go home and not have internet again today. I'll be dealing with my phone company that has had 3 outages of 24 hours or more in the last month, and numerous problems with my internet service. They have some rules and regulations that kind of, for lack of a better way of putting it, tick me off. I almost said the other word, but anyway.
Right.
If you cancel them, they ask you to file or sign a 2-year commitment. The first year they give you a reasonable rate. The next year it's basically gouging, like $49 for the most basic internet, $49 a month, because they have a monopoly in our area. They also told me that with these 3 outages, the only people that are going to get credit on their bill are those that actually ask for them. And if you try and call them now, there's about a 45-minute wait, even just to get even to get technical support help. So they're kind of in a shambles, but their bill collecting seems to be working just fine, but everything else is not working.
Right.
So I'm kind of curious about if the people, now the last outage was from Harrisburg all the way to Tomahawk in Pennsylvania. So we're talking probably hundreds of thousands of internet users that couldn't use their internet for 24 hours or more. And I'm just curious if that would be something that you could file a class action suit. The reason I'm asking as a class action was I think I remember in the past I was going to file a complaint with the FCC, and they told me that they're not regulated by the FCC anymore since it's deregulation.
Interesting. Now, of course, we have to look at the contract that everybody signed, right?
Mm-hmm. Well, they're really, they originally there was no contract. They did all this stuff over the phone, which is another problem that you have with them. They'll call you up and say, hey, your contract's coming to an end. We'd like to offer you this sweetheart deal. You accept the deal. The next month, you're paying $49.99 a month. And they say, who'd you talk to?
Right.
I said, whoever called me. I don't know who called me. I figured you were going to honor it since you called me.
Right.
So,
I've heard this before.
So it's really, it's really bad. I'd love to name the company on the air, but I don't think you'd like
Yeah, don't, because we like to, we don't like to.
They're not, let's put it this way, they're not an advertiser at your station, and they're not the one with union workers that are picketing anywhere, but it's another one. But anyway, my point is, if people did form together, would they be able to file a class action suit? And do you think it would be to the benefit? Because, like I said, there's probably hundreds of thousands of people that aren't going to get credit because they're either so frustrated that they don't want to ask for it.
Yeah,
and I do think that they should not charge you a cancellation fee if they can't provide the service. They're talking like $175 fee to cancel them,
right,
with something else, and when they can't provide the service.
Yeah, I understand what you're saying, and they make it very difficult to cancel. You know what? We'd have to look at the contracts. We'd have to look at everybody's situation. But the short answer is, yeah, you potentially would have a class action there. I just don't.
That does that?
Well, there's various law firms that do them. It's a question of getting a lead plaintiff and discovering it. So usually what happens is somebody kind of digs in on a case, finds out what's going on, and then hands it off to a firm that does class actions, or sends you directly to one. So we'd have to find one. And we'd have to make sure the class is sufficiently large and the damages are, interesting so that you get the big boys interested. Because it is a big load of work.
Okay.
Now, certifying a class is the easy part, I guess, because anybody can file their own lawsuit and then ask to certify a class of people. And then if a court does that, then that's when it gets really complicated because then you have to start notifying everybody in the class of their rights, et cetera, et cetera. So, yeah, but it's interesting. I think you're onto something. I don't know.
It seems to be the only – there is no power. Deregulation was a wonderful thing at the time. It seemed like a great idea. But, you still have utilities in certain areas that basically have the monopoly.
Right.
We can't get any other phone company in our area. And it seems like they actually – the phone companies that were supposed to compete against each other have done what the legislature did with redistricting. They said, here's your area. You're safe. Here's your area. There, you're safe.
Right.
We won't compete. We agree not to compete against each other.
Well, you don't have an express agreement, right?
Yeah. Well, it's probably not on paper or on email anywhere, but over cigars and cognac, there's probably an implied agreement somewhere.
Well, if they get lucky, they can always get a legislative fix on that too, where they have. Remember tobacco.
Hey, Carl, no offense, but I don't want the legislator to fix anything anymore.
Right. Well, no, they say, remember tobacco, what Big Tobacco did? They said, we want to enter into a settlement, and as part of the settlement, we'll agree to no outdoor advertising.
Yeah.
And, of course, what they essentially did was remove outdoor advertising as a form of competition in their industry. It's the same reason why the liquor companies for years used to informally agree not to advertise on network TV. Because if I sat down with all my other competitors and said, we'll all agree not to buy Yellow Pages, all us attorneys will get out of the Yellow Page, that way we won't have to pay all that money to those thinkers, that would be illegal. But for some reason, when you're the tobacco companies, you get an act of Congress to sign off on it. And for some reason, when you're the liquor people, you get away with it because everybody thinks you're doing a public service by standing down on your advertising budget.
Oh, my.
Anyhow.
Well, anyway, thanks, Carl. Thanks.
All right.
For the
yeah, it's interesting. I think you're onto something.
Okay, well, I appreciate that. It's you're the first person to tell me that. My wife says I'm usually not.
Well, that's what she's there for.
Yeah. All right, have
Dan.
a good one.
540-0580, Carl Rominger here answering your legal questions. John, you're on the air.
Hey, Carl, how you doing?
Good. What's going on?
Good. I got a hypothetical kind of a story with a twist.
Okay.
I got curious about. If a person is heading down the road and is impaired in some way or distracted in some way and hits somebody and puts them into a state where they're injured and put into a coma, vegetative state or whatever, and 3 months later or 6 months later, I've been in jail, done whatever I've had to do. 3 months later, 6 months later, the family decides to pull the plug on that person.
Right.
That person passes away. Am I now charged with murder?
You mean you created the injury, which led to them in the vegetative state, right?
Right, but they could have stayed in the vegetative state indefinitely.
Yeah, the short answer is yes. In fact, I was involved with a case like that years ago where they pulled the plug on somebody, and then they promptly charged murder because they were declared, to be brain dead. So now, I guess if you could make an argument that they didn't need to be and they could have recovered, but I think I've seen some litigation on this, and I think you're kind of stuck. That as long as your actions are what led to the death. Now, there used to be a rule, and I don't know if it's still in place or not, about how much time had to elapse before you were in the clear. The theory being that if you created a medical condition in somebody but they lived for a few years, we wouldn't per se hold you liable for that, for the death. But I think that's no longer the case. So I'm just thinking out loud. But, yeah, it is a problem. If I take you off of life support, the guy that shot you potentially then becomes a murderer instead of a attempted murderer.
Okay, even though if you stayed on the life support, you're technically still alive.
Right. And now, of course, we're getting farther down the rabbit hole because as the technology improves, and they're now talking about the ability to, bring people back who are locked in. Yeah. Through technology, and potentially also I saw where they're able to heal brains, where they're putting people's heads and chilling the head while they warm the feet, so that over a long period of time while you're in a coma, you get some regeneration. Although the interesting question is, a lot of times if you have severe brain damage and they do bring somebody back, a lot of times they're not the same person they were when they went under. So,
right.
Did the old guy die?
Yeah, it's just something that's been floating around in my head.
Yeah, no, it's interesting. It's an interesting question, but the reason I know it to be the easy answer is practical experience. I had a case where that happened, and then the murder charge promptly followed. So unless I terribly dropped the ball, I'm pretty sure that's the case.
All
right, my friend.
I appreciate it. Thanks.
540-0580. Well, that's some snazzy music. Okay, as promised, I'm going to take John and Mike. Hold tight for a second. 540-0580. As promised, I posted the factors to consider when awarding custody on my Facebook page, so you can follow along there. Factors. The legislature says in 5328 subsection A, and that's not the pejorative legislature. This is the legislature we like. In ordering any form of custody, the court shall determine the best interest of the child by considering all relevant factors, giving weighted consideration to those factors which affect the safety of the child, including the following. Number one, remember this, which party is more likely to encourage and permit frequent and continuing contact between the minor, or between the child and another party? Let's see here. Number two, the present and past abuse committed by a party or member of the party's household, whether there's a continued risk of harm to the child abused party, and which party can better provide adequate physical safeguards and supervision of the child. 3, the parental duties performed by each party on behalf of the child. 4, the need for stability and continuity in the child's education, family life, and community life. 5, the availability of extended family. Hey, I got the grandparents in my area. The child's sibling relationships. Hey, if you're going to break these kids up, well, I've got the stepbrother here. 7, the well-reasoned preference of the child based on the child's maturity and judgment. My 4-year-old really doesn't want to go with his father. Big deal. My 17-year-old hates his mother. Might be relevant. The attempts of a parent to turn the child against the other parent, except in cases of domestic violence where reasonable safety measures are necessary to protect the child from harm. Hey, she's turning my child into a critic of mine and making my child believe that I am an evil alcoholic. And she even told the child that I beat her. Well, maybe if you beat her, it might become relevant so that he knows. Which party is more likely to maintain a loving, stable, consistent, nurturing relationship with the child adequate for the child's emotional needs? Dad's gruff, mom's not, or vice versa. So maybe that makes sense. Number 10, which party is more likely to attend the daily physical, emotional, developmental, educational, and special needs of the child? Important right there. Who's going to attend the daily physical, emotional development? Hey, my job is more flexible than hers. I can go home at any time. I can pick the kids up early or late. I can stay home with them if they're sick. So I am more fit under that criterion. 11, the proximity of the residences of the parties. If the residences are really close together, maybe we should have more exchanges of the kids. Whereas if they're far apart, we shouldn't be on the turnpike 2 hours every day. 12, each of the parties' availability to care for the child or ability to make appropriate child care arrangements. Let's see. The level of conflict between the parties and the willingness and ability of the parents to cooperate with one another. A party's efforts to protect a child from abuse by another party is not evidence of unwillingness or inability to cooperate with that party. She's more cooperative. He's less cooperative. That would be a criterion. 14, the history of drug or alcohol abuse by a party or member of a party's household. Her new boyfriend is a drug addict. Very relevant. 15, the mental and physical condition of a party or member of a party's household. She's in a wheelchair, and while she's a good mom, she's not as capable of doing things. Or he has a mental health issue. He's a psychotic. 16, any other relevant factor. There you go. Fill in the blank with that one. So those are our custody factors. You know, I just ran through them real quick, but you can find them posted right on my Facebook page. So just look them up there if you want to see them, and we'll go from there. John, what's going on? Hey, John.
Hello.
Yep.
Hey, Carl.
Hey.
Hey, I had called you about 2 months ago. I just wanted to end your show maybe on a lighter note about a weekly publication that kept throwing in my yard.
Yes, the littering newspaper.
Well, what I did was, after I talked to you, I sent an email to them, and I told them that I was going to charge them $10 a week for every time I had to pick up this newspaper and throw it away.
Mm-hmm.
And they emailed me back and said, okay, we've informed our circulation department to take your address off the delivery notice. And remember how we laughed about you never know who's going to be delivering from one week to the next?
Right.
It certainly wasn't going to be a kid because kids are lazy.
Yeah.
It lasted 3 weeks. I started getting it back again, and I said, that's it, I quit. You win.
Oh, that's funny.
It was just a funny thing. I mean, it was just, I wanted to give you a lighter note and not murder, not nothing. Just,
well,
you can't beat these people. But hey, they're making a living. So
when I graduated from when I graduated from college, you know, and they gave me this little exit interview, they wanted us to fill out this thing for the alumni development or whatever.
Mm-hmm.
And of course, I put in there like, do not contact me for money. I am just graduating, and I probably am going to law school, and I will need all my money for law school, and then I will probably need some money to get started. So do not contact me for money unless 5 years have gone by. And of course, every month you get the phone call from the college. Hey, we got a phone. I'm like, look in my file.
Yeah, how'd that work for you, huh?
Well, it didn't work at all. Of course not. I might as well put call me frequently down.
But anyway, love your show.
Well, thank you very much.
Bye-bye.
Take care. 540-0580. Mike, you're on the air.
Hey, Carl, thanks. I love your show, too. Hey, I got a question about a traffic violation my daughter got.
Yeah.
She was driving in bumper-to-bumper traffic in the city behind a large semi-tractor-trailer truck. And as she went through an intersection, she finally saw the light, and it was red. And when you know it, the cop pulled her over. She told him she couldn't see the light till she was actually in the intersection. He said, yeah, I was going to pull the truck over for going through the red light. Then I saw you. But you shouldn't have been following so close. But she said it was bumper-to-bumper traffic. Now, my question for you is there any benefit to going to court and telling the judge this?
Did they charge her with the red light violation?
Yes, they did.
Yeah, there is definitely viable to go to court. It may be defensible, although technically it's strict liability, so you're supposed to be able to see and maintain your distance, etc. But we've all been in that position where you're stuck, sandwiched up behind the truck, wondering what color the light is. I think everybody's been there. My other personal favorite is when you're passing the truck on the interstate, and for some reason, even as you're trying to pass the truck and you're trying to check the exit sign to see if it's your exit, somehow the truck manages to block the exit sign for a quarter mile. Anyhow, my point on all this is, yes, because it's something that could engender some sympathy. And while technically sympathy is not the issue at these kinds of hearings, district judges dispense what we call justice. And sometimes justice isn't always the rote letter of the law. And sometimes you can also get the police officer at that stage to say, oh, yeah, I remember this one. I wrote you up for the red light violation, but you were behind the truck, so I'll give you this other charge that doesn't carry any points.
Oh, okay. And that's what we're concerned with is the point.
Yeah. Yeah, so I think it's well worth taking the hearing if for no other reason than to do that.
Yeah. Okay, hey, thanks, Carl. Appreciate it.
No problem. Take care.
Thank you.
540-0580 is the talk line number. Call in. Of course, you can go to romingerlaw.com. And, of course, a minute ago I read the 16 factors for custody, which I just put on my Facebook page, so feel free to check those out. Rick, you're on the air.
Hey, Carl. Thank you very much. I have a question for you on mechanics liens.
Okay.
Did a job for some people locally who are out of Kentucky. They hired a general contractor out of Florida. Supposedly the property paid the contractor for my services, but the contractor will not even return my calls. I'd like to know specifications as to liening the property where the work was done.
Okay. So you want to put the lien in place, or you're worried about them putting the lien in place? I'm not sure I'm following.
No, I would like to put a lien in place for services rendered.
Okay, because you did work on the property.
I did.
And you haven't been paid yet?
Correct.
Okay. Did you sign any waivers of mechanics liens?
I signed a contract which I did not receive a copy of.
Gotcha. And you don't know if it contained a waiver of mechanics liens in it or not?
It probably did.
Yeah, that's going to be the issue, because you don't want to file a mechanics lien where you don't have the right to do one. And if you filed a waiver of one, I think the penalty can be fairly harsh for them to come back and say that you filed that in bad faith because you knew you'd waived your right to do that. But I don't know. You're saying you think it's in the contract, you're pretty sure it's there, but you don't have a copy. Why do you not have a copy?
They never provided me with one. I signed a contract that was not even signed on their side. They just gave me this contractor contract that I guess everyone signs. I signed it, and it went off to corporate. I never received a copy of my own.
Gotcha. I had that case one time years ago where we had a contract for a car, and they were saying my client signed the contract. And, of course, I said, yeah, but if it says right here, it says contract not valid unless signed by both parties. And the owner had never signed it.
Okay.
That got me some traction, but for some reason the judge wasn't as impressed with it as I thought he should be.
Okay.
So, the answer is, I guess you didn't get the signed contract, so now you have to reconstruct it. I guess the first step would be to request a copy of the contract. Now, do you think these people are out of business, or do you think they're just ignoring you, or what?
They're just ignoring me.
Interesting. Well, then the other way to go would be just to sue them. It gets the same effect, and you can drag them in. The nice thing about the mechanics lien, obviously, is it could create a title issue.
Okay.
So
I know that when I signed their contract, they requested the venue to be in Florida.
Yeah, that's even worse. All right. Well, your short answer. And how much money are we fighting over?
$14,000.
Yeah, it's worth fighting over. Well, if you don't have the contract, then you're saying, I guess that's the first thing I would do, send them a letter and demand they provide the contract and payment, and then maybe try to use that as a hook to drag them here. There's some things you could do.
Okay.
So, Rick, if you got a chance, just contact us off the air, and we'll be happy to talk to you about the different options.
Great.
All right, my friend.
Thank you.
540-0580. See you after the break. I left some stuff in the car I brought over here for RJ. I'll have to remember to get it out before I leave. Brought him some very important papers. So maybe he will. Maybe he'll tell his listeners about the very important papers that I'm dropping off for him on Monday. I don't know. I'll leave that up to him. 540-0580. John, you're on the air.
Hey, Carl, I got a fun question.
Yeah.
Let's say I win the Powerball today.
Okay. You're not, but go ahead.
What?
I am. Oh, okay.
Which way would be the least amount of tax burden? Should I take the annuity? Should I take the $96 million and then they take the $20 or $30 million in taxes?
Well, the tax burden is interesting because if you take the annuity, you're going to take the tax on each annuity payment. So who knows what the future will hold there? Okay.
Okay.
Congress could, based on the fact that they're about to dump our economy into the toilet, eventually need lots of tax revenue, more so than now. The lump sum obviously gives you the most money to play with right away.
But then if I give some to my kids or something, and I'm taxed on it again.
Potentially, yes.
Yeah.
Yes. So that's where I would want to call our good friend Mark Virginis and have Mark weigh in on what would be the best way. I know that Mark has in the past talked about with lottery winnings using a trust to claim the winnings, but I don't think we've ever discussed should you take the annuity or the lump sum and what are the advantages of one over the other.
Maybe that'd be a future question.
That sounds like a good one for him. Maybe he's probably listening. He'll chime in at some point, but we're going to run out of time for today. But I will bug him about that. I like that. That's a good question. Because the lump sum gives you more money up front, but the annuity grows tax deferred.
Right.
So, boy, I think you know what? You really have to look at. Did you notice this? The lump sums are bigger versus the total amounts than they used to be.
Yeah, they used to only be half. Now they're about 55 or 60%.
Yeah, and I think that has to do with the fact that the annuities don't pay as well. So in order to, the cost of the annuity is more expensive. So I have a feeling that's why that's the case. Because you're getting the cost of the annuity is the cash settlement versus the annuity, I think. And I think that's why, because we see that in the structured settlements in the personal injury arena. And, of course, if people have a personal injury claim, sometimes we get them money over time in what's called a structured settlement, which is kind of like an annuity, but it's a unique beast just to personal injury law.
Mm-hmm.
And, the rates are so low that the life insurance companies aren't willing to lock into really high rates of return. So it's much more expensive to purchase the same contracts that we could have purchased for less in the past. And I think the lottery is just tracking the same direction because it's the same idea.
I see.
All right,
thanks.
Thanks, man. Mac, you're on the air.
Hey, Carl.
Yeah.
Say you got a client and you get him off on a capital case, all
okay.
right? And on the way out the courthouse after you've got him acquitted, he says to you he did it and he's going to do it again. What's your responsibility there?
Well, that he did it, no responsibility. That's completely privileged.
Right.
That he's going to do it again, I may breach privilege to help protect somebody. I don't have to, but I may.
Mm-hmm.
So, theoretically, now here's the lawyer's dilemma, right?
Yeah.
I breach privilege and say something, and then he later says, that's not exactly what I said, and he's overblowing it, and I wasn't really a threat.
Mm-hmm.
The question is, what's the safe harbor?
Yeah.
So the smart practitioner just keeps their mouth shut because then they're not going to have any danger of being in trouble for breaching confidentiality because since they could have done it but didn't have to, that's always the safest bet on a game theory analysis.
Right.
Now, that said, there are times, I can think of a time recently where I went to a judge and said, hey, judge, I have reason to believe that my client may engage in self-harm if allowed to roam free. And the ethical rules say that I can call to a court's attention somebody's danger or incompetency or other things like that.
Right.
I don't have to. But I don't really want my client killing himself. But then again, he hadn't paid the whole bill yet.
Right.
So, those were the thoughts.
Thank you very much.
All right, my friend, take care.
Bye-bye.
And I'm just kidding about the part about the bill, okay? I know Shane looked horrified for a second there. Anyhow, seriously, though, and you don't really want to see anybody hurt. And so one of the things, if a client did say to me that they were going to hurt somebody, we would try to talk them down and figure out what they need for help. I've sent a large number of people over to various psychologists and psychiatrists over the years for assistance and counselors. I don't think most people are really looking to hurt anybody. And, of course, beating a capital case is almost near next to impossible. I did do a capital case one time where I got a what I want to say, where I got my client third-degree murder, but they're still in prison, so they're not going to be doing much. Anyhow, long story short, I would recommend to any attorney, if a client's going to threaten to harm somebody, to try to intervene as best as possible and maybe take that risk, because I have a feeling that the Bar Association, or in this case the Disciplinary Board of the Pennsylvania Supreme Court, is not going to bend over backwards to disbar you because you in good faith tried to help somebody. However, there are ethics opinions out there for lawyers which suggest that seeking ethical advice ahead of time is helpful because it provides some protection from bad choice. But nonetheless, even if you receive wrong advice, you can still be found to have breached your ethics. And so that's always a scary thing when you get to that line and go, should I or shouldn't I report this person? One thing we can't do, for instance, is help with fraud. So anyhow, we talked about that. So, guys, I'll be back next week, 1 to 3, answering your legal questions here on WHP 580. In the meantime, go to romingerlaw.com, ROMINGER law.com, or 241-6070. Law office number is 241-6070. And, of course, you can always Facebook me. It's Carl with a K, Rominger, ROMINGER. Talk to you later.